record in the matters of the people of the state of Michigan versus Tavari McMiller, 24-01574, and Jace Bunkley, 24-01572. Council appearance.
Good morning, Your Honor. Natalie Macomber on behalf of the people.
Good morning, Your Honor. Lana Berry appearing on behalf of Tavari McMiller, who is seated behind me for convenience and seating efficiency.
Okay, today was the date set for a determination on the bind over. I've received arguments, heard arguments, some on the record, and received the people's bind over brief. I assume that the defense counsels got copies of the bind over brief from the people as well, correct?
That's correct, yeah.
Okay, and I reviewed that as well as the exhibits again in chambers. Is there any additional matters that we need to address or argument before I make a ruling?
No, Your Honor.
Okay. Your clients can come forward. This information.
Are you only handling Mr. McMiller's right now? I noticed I don't think.
No, I didn't put my appearance on the record, but Kareem Johnson will be after this. Jason.
That's all.
We're handling them. They can come forward though, the next two will. Okay, and so, and you can feel free to be seated. This should be extra seats over here. Okay, I can't even say today because this is a matter that's been pending for a matter of days, months, because of the amount of times that we came before the court. I think we first took testimony back in June, and here we are in November. And so this was the continuation of a preliminary examination. The purpose again of the preliminary examination is to require the prosecution to put forth evidence that would establish sufficient probable cause that a felony was committed and then probable cause sufficient to charge you with the felony. This is not a trial. They don't have to prove each element beyond a reasonable doubt. The court will be the determiner and the sole determiner of any credibility issues of the witness at the time of the exam, and then also weigh the people's likelihood of success at trial. And so again, we heard testimony over a series of different days from various officers. First beginning with an officer, Benjamin Brandenburg, that is, from VCI, Violent Crime Initiative. He testified that on or about the time of May 29th, 2024, he was conducting surveillance in the area of 4245 West Jolly. Kensington Meadows is what he described the area, in Ingham County, state of Michigan, making a city of Lansing making venue in this court appropriate. That he was doing surveillance in investigation of a homicide. That he testified that he was aware that an individual identified as Tavari McMiller had a warrant, and that he identified or three subjects enter a vehicle that he described Tavari to enter into the driver's seat. That Tavion McMiller, or individual identified as Tavion McMiller, who was originally a co-defendant but later dismissed, got into the rear driver seat, and that third co-defendant, Jace Bunkley, getting into the rear passenger seat. So Brandenburg testified that he identified Tavari McMiller to get in the driver's seat and remove a object that he described as a black object from under the seat. He described it being pointed down and that was taken from under the driver's seat area. He described it to be about 5 inches in length and L-shaped. He described it being handled with an overhand grip of the object, and that Mr. Tavari McMiller moved that object in a way in which it would be as if he was clearing, typically used to clear a firearm, but that Mr. Tavari McMiller passed that object backwards to the backseat passenger. Officer Brandenburg testified that he advised other units of his observation, and a traffic stop was performed at the area of Stillwell and Lucy, also in the city of Lansing, Ingham County, state of Michigan. So officers testified, Officer Brandenburg testified that Bunkley was removed from the vehicle and that the front seat passenger was a female passenger was removed. Female passenger, and I believe the owner of the vehicle was removed from the front seat, and officers interviewed the front seat passenger and the rear seat passenger. Mr. Tavion was detained and Mirandized, and Tavari was ultimately arrested on a pending warrant taken and questioned about. So there's been argument made by the defense that the people's evidence should be suppressed if there was an unlawful search and seizure. That the stop was pretextual, and the people are arguing that and if you consider the totality of circumstances, that the bind over is appropriate because the officers had a sufficient probable cause to make a warrantless search of the vehicle. I reviewed the body cam and the other exhibits, video exhibits that were admitted, as well as a review of the arguments made by attorneys for and against bind over. One thing that pointed out to me as it relates to the motion to suppress the search, the evidence of the search, was that when I reviewed Brandenburg's body camera, I could see Officer or Trooper Schaefer, that is, originally look after removing that front seat passenger, he backs up, removes his glasses, and he's appearing to try to look underneath the seat of the vehicle. Doesn't appear that he sees anything at that time. He says nothing. He goes back to the car, places his hand on the door, while the other officers are handling some of the other suspects in the vehicle. Mr. Jace Bunkley, or the person identified as Jace Bunkley, is removed from the rear. As that is happening, while I'm still watching Brandenburg's body worn camera, I can see Officer Trooper Schaefer in the background. Again, attempting to look under the seat. I see him bend down at approximately 4:13 into the video. He's bending down. He had already backed up and removed his glasses again. It again appears that he sees nothing, but then he bends down even lower. From my vantage point, it is clear that he breached the threshold of that vehicle when he bent down further. He bends down at about 4:23. Well, he stands up, he goes back down at about 4:23, this time with a flashlight. And it's after that you hear him utter the words that it sounds like 52, which indicates that he's found the firearm. So the question is whether or not he breached the threshold of that vehicle. From my vantage point, I think it's clear. He definitely breached. That's why it to take him so many times to go under. Even when I reviewed, I think it was Exhibit 7, it's another body worn camera. I could see that officer was on the opposite end of the vehicle, and the passenger, front seat passenger. Rear backseat passenger side. You can see Trooper Schaefer again trying to get a vantage point underneath this seat. Also understanding that where this weapon was allegedly located is in an area where they described had to be placed from the back seat in the first place. Nonetheless, I believe there was a breach. However, I believe that the officers already had probable cause to search the vehicle, because you have to look at the totality of the circumstances. We have first officers that are operating under surveillance for a tip of a threat of violence at a visual, that officers already have no knowledge of these individuals, or at least it was clear to me based on the testimony, they had knowledge of Mr. Tavari McMiller. Maybe he was wanted to be so that they can speak to him about an unrelated situation or related situation, a homicide. Maybe not, I don't know. However, we also have Officer Brandenburg's statements, which were dispatched, and other officers who have corroborated that, which was that he observed something L-shaped, black in color, be handled in a way that's consistent with their knowledge and information as a firearm, being pulled from up under the seat and placed over the arm to the backseat passenger. Officers, under their training and experience, believe that to be a firearm. Then officers have a vehicle that does not have an insurance, which means that vehicle could have been towed and searched and sent into a tow. Also, we have a driver, the same person that allegedly is observed placing an object or handling an object that appears to be a firearm to the backseat. That person has an active warrant. There was already probable cause there. The court is satisfied based on that there was sufficient probable cause to search, that the motion to suppress is denied. As to whether or not there's probable cause sufficient to bind over each being charged with a carrying concealed in the vehicle, to prove that at trial, the people would need to prove the defendant is charged with a crime and that carrying a pistol in the vehicle, and that the pistol was in the vehicle that the defendant was in. Second, that the defendant knew the pistol was there. Third, that the defendant took part in carrying or keeping the pistol in that vehicle. Again, reiterating the previous testimony, it's officers observed the driver, who they identified to be Mr. Jabari McMiller, enter the vehicle, remove something from up under the seat, pass that to somebody in the back of the seat. Officers search the vehicle and later find a firearm. There's sufficient probable cause to bind over for Jabari McMiller. So that will be bound over. As to Jace Bunkley, same facts, only that when questioned, Mr. Bunkley admits to the firearm. There's sufficient probable cause as to the second firearm that's found in the center console in the back of the car to be bound over for Mr. Jace Bunkley. Bind over date's going to be November 20th. That's the date the circuit court's going to get the file from the district court. Neither of you all need to appear in the circuit court on that date, okay? Your next court date will be a pre-trial in circuit court. Your attorneys will be made aware of that date. Do you have any questions for the court? Bond for Mr. Bunkley was 2,000 personal recognizance. That will continue. Mr. McMiller's bond is 3,000 personal recognizance, and that will continue. Any additional matters for the record?
Nothing on behalf of Mr. McMillan. Thank you.
No, yeah, thank you.
Thank you. You're all set. I think it might be time to turn the heater off. I think it might be time to turn the heater off. If not, I'll turn the same sort. These motions should have been. To the judge's copy, the ones that they find should have been added to the file. Or still need to be added to the file, not please like that. These ones don't. Just the ones, yeah, the ones that say judge's copy don't need to be added. Those are the ones that I can write on.
Morning, Your Honor. Here on the Robinson matter, and it seems like it's going to be a waiver.
Is in custody?
Yes,
Yes,
he is.
he is.
It's going to be brought up.
It can be brought up. On the record, in the matter of the people of the state of Michigan versus Dante Robinson, 24-01641. Appearance, please.
Yes, good morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, on behalf of Mr. Robinson.
Okay, Mr. Robinson, today was the date that was scheduled for a preliminary examination, and then there was a PA 53 contempt. Was that because of jail calls or something else?
Jail calls, Your Honor.
Okay, how are we proceeding today?
Your Honor, we have made an offer to defend. I believe that the defendant would like to accept as a felony offer, and therefore we can't take it here. But the intention is to hold the arraignment at circuit court. That normally doesn't happen, in order to make sure that the plea happens as quickly as humanly possible for him. As a result, I believe it's the intention to waive the examination today. And I'd be happy to place that offer on the record, so that way it is immortalized.
Yes.
That is my understanding as well, Your Honor.
The offer is for the defendant to plead guilty to count three, aggravated stalking. In exchange, people would dismiss the remaining charges, dismiss the habitual offender status, agree to no further upfront jail at time of sentencing, and agree not to pursue witness interference charges for contacts made prior to today's date, November 8th, 2024.
Ferguson, that's complete and accurate.
Yes, it is, Your Honor.
Yes. I mean, you're already there. You just really just needed to reach.
Sorry, Your Honor.
You didn't have to approach. The courtroom's not big enough to request. Okay, so Mr. Robinson, you understand that you have the right to have a preliminary examination in this file.
Yes, ma'am.
They understand that the purpose of the exam is to require the prosecutor put forth evidence that would satisfy the burden of probable cause. So that's probable cause that these felonies were committed and probable cause that you committed these felonies. You understand that?
Yes, Your Honor.
Do you wish to unconditionally waive your examination? You're looking like, what do you mean about that? And then that unconditional part threw you off,
I would
correct?
disagree.
Yeah, do you have to unconditionally waive it, meaning no one's threatening you,
No.
no one promising you anything?
No, ma'am.
You don't believe that this is based on some condition, and then if it don't work out, you can come back. If you get to circuit court and things don't work the way you thought, you don't get to decide you want to have your exam. You understand that? You don't understand that?
Yeah, I do.
You sure?
Yeah, I'm positive.
You positive?
Yes,
Is
ma'am.
anybody threatening you to waive your exam?
No, ma'am.
Has there been any promises to get you to want to waive your examination? And you're waiving your exam freely and voluntarily?
Yes, ma'am.
Okay. Your bind over date is November 20th. Your attorney is going to make a motion for you to be arraigned in circuit court,
That's
correct?
correct, Your Honor. I think I have to email somebody at pretrial services. I'll do that this afternoon.
I've also noted in the file that it's expected to continue to arraignment in circuit court. That way you'll have a court date on November 20th, okay?
Okay.
A bond in this matter was set, the 125,000 cash surety with GPS tether and victim notification, and there's a no contact order that will continue. Any additional matters for the record?
I think we still need to address the PA 53, Your Honor. Check on books.
Are we running a hearing on that?
I will say I'm not going to be requesting any additional time, but it is on the books if he's going to accept. That's his face on there. Otherwise, I have to pull the officer in and play the videos.
You want to talk to him in private about that? I don't know what
That's
he's,
fine.
fine with what?
Yeah, miss.
He wants to make a mission, huh?
You want to admit to the violations? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Okay, so the allegations are that you violated the terms and conditions of your bond by having contact with the protected party, primarily or namely through phone, e-messages, and video from the Ingham County Jail. As to those violations, did you have the right to have a hearing, a contested hearing today? And it sounds like the people are prepared to bring the officer in for that purpose and present evidence. Do you want to waive your hearing and plead to those violations?
Yes, ma'am.
Is anybody threatening you to do that?
No, ma'am.
Any promises?
No.
Factual basis?
Yes, Your Honor, Mr. Robinson, you were arrested on this case, is that correct?
Yeah,
And you were arraigned, is that correct?
correct.
And you were given an order not to have any contact with a Victoria Mayfield, Maynard, is that correct?
Correct.
And you did what with regards to that order, Mr. Robinson?
Contact.
How did you contact her?
Video.
Video, and that was at the Union County Jail, is that correct?
Yeah.
That you knew that was in violation of the court order at the time you made the call?
Yeah.
No further questions, Your Honor.
Any questions from the people?
None, Your Honor.
The court is satisfied with the plea to the violations. I'll accept your plea and find it to be freely, voluntarily, and intelligently made. I think you were arraigned on these back on the 20th of September. I credit you time served.
Thank you, Your Honor.
Thank you.
Any additional matters for the record?
Not from the people, Your Honor.
Judge, may we address bond?
Yes.
I know bond is presently set at 125,000. Your Honor, I'd ask for a reduction of bond. There's been a reduction in this case to offer you wish to accept. I would ask for a reduction of bond.
He's not accepted the offer.
Well, he will be accepting the offer when we get this report.
Well, then he can make that motion before the circuit court on the 20th.
Your Honor.
You're all set. Is that all I have for criminal today?
All you have, Judge.